Right now, as you are reading this, there are tens of millions of Americans, your neighbors, your coworkers, veterans who served this country, people who made one mistake decades ago, people who took a legal edible in a state where marijuana is fully legal, who are permanently, federally, irrevocably banned from owning a firearm, not because of anything they did yesterday, not because they're violent, not because a court recently ruled them dangerous, because of a law written in 1968 that has quietly grown into one of the most sweeping, selectively enforced, constitutionally questionable weapons the federal government has ever turned against its own citizens. And right now, in March of 2026, the Supreme Court of the United States is sitting in that marble building in Washington, D.C., deciding whether this law can keep standing or whether it finally gets what it deserves. America's new gun permit law has effectively banned millions from owning firearms forever. And the scariest part? Most of those millions don't even know it yet. If you care about your constitutional rights, if you care about equal justice, if you care about what this country actually stands for versus what the powerful claim it stands for, you need to stay right here. And before we go any further, if you haven't subscribed yet, do it right now. Hit that button. Because we cover the stories that the mainstream media buries, the cases that reshape your rights without a single primetime segment, the legal battles that will determine what kind of country your children inherit. Subscribe, leave a comment below telling me what you think. Should drug users lose their Second Amendment rights permanently? And let's get into this. Here is the law at the center of this entire firestorm. It's called 18 U.S.C. Paragraph 922G, and it lives inside the Gun Control Act of 1968. Most Americans have heard of background checks. Most people vaguely know that felons can't own guns. But what most people don't realize is just how broad, how sweeping, and how jaw-dropping the list of people banned from firearm ownership actually is under federal law. We are not talking about a narrow prohibition. We are talking about 9 separate categories of people who are permanently stripped of their Second Amendment rights under federal statute. 9 categories. And if you fall into any one of them, a gun purchase, legally, is off the table. Period. The penalty for violating this law is up to 15 years in federal prison. Let's lay out who we're talking about. Convicted felons. Anyone convicted of a crime punishable by more than 1 year in prison. Fugitives from justice, unlawful users of, or people addicted to any controlled substance. People who have been adjudicated as mentally ill or involuntarily committed to a mental institution. Illegal immigrants and non-immigrant visa holders. Anyone who has renounced their citizenship. People subject to certain domestic violence restraining orders. Anyone convicted of a misdemeanor domestic violence offense. And people who have been dishonorably discharged from the military. That is the list. 9 categories. And between them, they encompass an absolutely staggering portion of the American population. Let's focus on just the felony prohibition for a moment, because the numbers will make your head spin. Recent estimates put the number of Americans with felony convictions somewhere between 19 million and 25 million people. 25 million people who are, by federal law, permanently banned from owning a firearm. That's more than the entire population of Florida. And here is the critical detail that gets glossed over in every comfortable Washington conversation about gun control. The overwhelming majority of those felony convictions are not for violent crimes. They are for drug offenses, for theft, for white-collar crimes, for regulatory violations, for all manner of nonviolent conduct that puts someone in front of a judge at the worst moment of their life. And the punishment, in addition to prison time and probation and fines and a lifelong scarlet letter on your record, is the permanent, irrevocable loss of your constitutional right to bear arms. Forever. No review, no second chance, no path back for most. Now add to those 25 million the drug user prohibition, specifically 18 U.S.C. Paragraph 922G3, which bars anyone who is an unlawful user of or addicted to any controlled substance from possessing a firearm. This is where the numbers become truly staggering and where the constitutional hypocrisy becomes impossible to ignore. According to the most recent data, approximately 44.3 million Americans use marijuana every single month. 64 million used it within the past year. Marijuana is now legal, recreationally or medically, in 40 of the 50 states in this country. 40 states. People in those states are buying marijuana legally at licensed dispensaries, paying state taxes on it, following their state's laws in every conceivable way. And under federal law, every single one of them is technically a prohibited person under 922G3. Every one of them is technically committing a federal felony if they own a firearm, and that felony carries up to 15 years in prison. That is the scale of what we are dealing with. This is not a fringe issue. This is not a technicality. This is a structural contradiction at the heart of American law that touches tens of millions of lives, and it has been allowed to fester and grow for decades because the political class found it convenient to ignore. Now let's talk about the case that ripped the lid off this entire issue. United States versus Hemani. Remember that name. On March the 2nd, 2026, just days ago, the Supreme Court of the United States heard oral arguments in this case, and what happened inside that courtroom was nothing short of extraordinary. Here are the facts of the case. Ali Daniel Hemani is a Texas man, a dual citizen of the United States and Pakistan. In 2022, the FBI searched his home in the Dallas area. When they got there, they found a handgun that Hemani had purchased legally, marijuana, and cocaine. During the search, Hemani told FBI agents that he uses marijuana every other day. On that basis, his admission that he uses marijuana every other day, the federal government charged him with violating 18 U.S.C. Perv 922G3, the prohibition on unlawful drug users possessing firearms, a violation of a law that carries a maximum sentence of 15 years in federal prison. Now, the government has tried to characterize Hemani in the worst possible light. Federal prosecutors have asserted that Hemani and his family have ties to Iranian entities hostile to the United States. But here's what matters legally. Here's what matters constitutionally. He was not charged with anything related to terrorism, not charged with any national security offense, not charged as a foreign agent. He was charged with one thing and one thing only, being a marijuana user who owned a gun that he had purchased legally. The government's entire case rests on the fact that he smoked weed every other day. The district court threw out the charges. The Fifth Circuit Court of Appeals, one of the most conservative appellate courts in the country, upheld that decision and declared that the federal law, as applied to Hemani, violates the Second Amendment. The government then appealed to the Supreme Court, and that is what brought us to March 2nd, 2026. 9 justices wrestling in real time with a question that strikes at the core of what the Second Amendment actually means in modern America. What happened during those oral arguments was remarkable. The Supreme Court's own conservative majority, the same justices who in 2022 handed down the landmark Bruen decision expanding gun rights, appeared deeply skeptical of the government's position. Justice Amy Coney Barrett, a conservative stalwart, pushed back hard on the government's attorney, Principal Deputy Solicitor General Sarah Harris. Barrett asked point-blank what the government's evidence was that using marijuana a couple of times a week makes someone dangerous. She raised the example of someone illegally taking Ambien, the sleeping aid, without a prescription. Is it the government's position, Barrett asked, that an unlawful Ambien user becomes too dangerous to own a gun? She rattled off a list: Robitussin, Xanax, Tylenol with codeine, testosterone, Adderall. None of those drugs, she said, strike me as drugs for which it is obvious that a risk of violence would ensue. That is a conservative justice appointed by Donald Trump, appointed to the highest court in the land, calling out the government's own argument as unsupported and intellectually hollow. Justice Neil Gorsuch went further. He zeroed in on the government's central historical claim, that the drug user gun ban is constitutionally valid because it is analogous to founding-era laws that disarmed habitual drunkards. That is the entire legal argument the government is standing on, and Gorsuch absolutely dismantled it. Let's dwell on Justice Gorsuch's challenge for a moment because it represents one of the sharpest, most devastating interrogations of government overreach that we have seen in a Supreme Court chamber in years. The government stood there and told the justices, with a straight face, that the 1968 law prohibiting drug users from owning guns is directly analogous to colonial-era laws that stripped habitual drunkards of their firearms. That's the argument. That's what the federal government is asking 9 Supreme Court justices to accept. That a person who uses marijuana every other day is constitutionally equivalent to an 18th century habitual drunkard, and therefore can be permanently disarmed. Justice Gorsuch's response was devastating in its simplicity. He reminded the government's attorney that John Adams, the second president of the United States, a founding father, one of the architects of the very constitutional framework being invoked, took a tankard of hard cider with his breakfast every single morning. He noted that James Madison reportedly drank a pint of whiskey every day. He pointed out that Thomas Jefferson, the man who wrote that all men are created equal, the man whose words formed the philosophical bedrock of this republic, consumed 3 or 4 glasses of wine every single night and claimed not to be much of a drinker. Gorsuch asked the government, under your theory, were these men habitual drunkards who should have been permanently disarmed? Were the founding fathers themselves too dangerous to own guns by the standard the government is now applying to Ali Hemani? That question does not have a clean answer. And that's the point. The government's attempt to dress up a 1968 statute in founding-era clothing falls apart the moment you apply it honestly. The habitual drunkard laws of the 1700s were not broad categorical bans on gun ownership for anyone who consumed alcohol regularly. They were narrowly targeted at individuals who demonstrated specific patterns of dangerous, out-of-control behavior. They required a showing of actual, observable danger, not merely the fact that someone consumed a substance. And they certainly did not cover casual, moderate users who gave no indication of being a threat to anyone. What the government is doing, what it has been doing for decades under 922G(3), is taking that narrow, historically specific founding-era concept and stretching it into an open-ended categorical ban that sweeps up tens of millions of Americans based on nothing more than the fact that they consume a substance that the federal government has placed on a prohibited list, a list that itself is increasingly out of step with reality. Because here is the part of this story that reveals the full scope of the government's contradictions. President Donald Trump's own administration has been actively pursuing the reclassification of marijuana. The executive branch has been taking steps to acknowledge that federal marijuana scheduling is outdated and scientifically unsupported. And yet, simultaneously, Trump's Justice Department went before the Supreme Court of the United States to argue that marijuana users should permanently lose their Second Amendment rights based on that very same classification. That is not governance. That is the government arguing out of both sides of its mouth while millions of Americans lose their constitutional rights in the middle. Now here is where the story gets even uglier, and where the real machinery of power in this country becomes impossible to hide. There are, conservatively, tens of millions of Americans who are technically in violation of 922G(3) right now. 64 million people used marijuana in the past year. A significant portion of them also own guns, either legally purchased before their drug use began, or held under the mistaken belief that state legalization protected them. By the federal government's own logic, every single one of those people is a felon. A 15-year felony felon. How many of those tens of millions of people do you think are actually prosecuted every year? The answer should embarrass every person in Washington who has ever used gun safety as a talking point. According to federal data, somewhere around 300 people per year are charged with 922G(3) as the lead offense. 300 out of tens of millions. That is not law enforcement. That is selective enforcement, and the question of who ends up in that 300 is not random, is not blind, and is not fair. You know who ends up in that 300? Not the wealthy marijuana user in a legal state who has his gun safely stored in a suburban home and a lawyer on speed dial. Not the businessman who takes his CBD and his prescription Ambien and his weekend edibles and never once worries about a federal firearms charge. The people who end up in that 300 are disproportionately poor, disproportionately black and brown, disproportionately from communities where law enforcement scrutiny is constant and relentless and not triggered by any particular danger, but by zip code, by appearance, by a traffic stop that never should have happened. This law, like so many gun laws that get championed as safety measures, functions in practice as a tool of racial and class subordination dressed up in the language of public safety. And let's not forget Hunter Biden. Let's absolutely not forget Hunter Biden. Because while we're talking about selective enforcement, while we're talking about who this law actually lands on, the son of the former president of the United States was charged under this exact statute, 18 U.S.C. paragraph 922G3, for owning a gun while being a drug addict. He was convicted, and then his father, in one of the most brazen abuses of presidential power in modern history, issued him a full and unconditional pardon. So for Hunter Biden, a wealthy, well-connected man with access to the best legal representation in the country, whose own father sat in the Oval Office, this law was a temporary inconvenience that ended with a pardon. But for Ali Hemani, for the thousands of other Americans charged under this same statute, there is no pardon coming. There is no presidential father. There is only a 15-year prison sentence and a lifetime loss of constitutional rights. This is the America that the political class has built. Two justice systems, one for the connected and one for everyone else. And the Second Amendment, supposedly the great equalizer, the right that belongs to every citizen regardless of station, has been carved up and commodified until it means something very different depending on which side of the economic line you stand on. If that doesn't make you furious, nothing will. Here is what is at stake when the Supreme Court hands down its ruling this summer, and why this decision, whoever wins, will reshape the legal landscape of gun ownership in America for a generation. Let's look at the possibilities clearly and honestly. If the Supreme Court sides with Hemani and strikes down the application of 922G3 to casual marijuana users, the immediate practical effect is significant. Millions of Americans who use marijuana in legal states would no longer be categorically disqualified from Second Amendment protections. The government would be forced, at minimum, to demonstrate actual dangerousness before disarming someone, not merely point to the fact that they consume a substance. This would be a major victory for civil liberties, for the constitutional rights of ordinary Americans, and for the principle that the government cannot simply write entire categories of people out of the Bill of Rights by classifying their lawful behavior as criminal. The ACLU, which has historically been deeply skeptical of expansive Second Amendment arguments, actually filed a brief in support of Hemani. The NRA and gun rights organizations also lined up on his side. That is how profound the civil liberties stakes of this case are. It created an alliance between institutions that almost never agree on anything. But the implications don't stop at marijuana. If the court rules that a showing of actual, individualized dangerousness is required before stripping someone of gun rights, that ruling echoes far beyond drug users. It reaches back toward the 25 million Americans with felony convictions. Many of those people were convicted of nonviolent offenses, drug possession, minor theft, regulatory crimes, decades ago, have served their time, have rebuilt their lives, and have never posed a danger to anyone. And yet they are still, today, permanently and categorically banned from owning a firearm. The court actually declined on March 2, 2026, to hear a parallel challenge to the felon in possession ban involving nonviolent offenders. But that case is not going away. It is coming. The logic of Bruen, applied honestly, demands that every categorical firearms ban be tested against the historical record of the founding era. And the founding era simply did not have a tradition of permanent, categorical, lifelong disarmament for nonviolent offenders. On the other side of the ledger, if the Supreme Court upholds the law, the message to tens of millions of Americans is stark and unambiguous. Your state can tell you marijuana is legal. Your doctor can prescribe you medication that happens to be federally controlled. Your governor can celebrate legalization and collect the tax revenue. But the federal government will still treat you as a second-class citizen under the Constitution, still reserve the right to charge you with a 15-year felony for the combination of a legal state activity and a legally purchased firearm, and there is nothing you can do about it. And that outcome, frankly, is untenable in a country that claims to be founded on individual liberty. The idea that the federal government can maintain a constitutional prohibition using an outdated drug schedule that its own executive branch is in the process of revising, that it can selectively enforce that prohibition against a tiny fraction of the technically covered population, while millions of others live in legal jeopardy they don't even know about, is not a serious legal framework. It is a fig leaf. It is the machinery of selective control dressed up as constitutional governance. We are living in a moment where the foundational rules of who gets rights in America are being rewritten in real time. Not in the streets, not in the halls of Congress, in marble courtrooms by 9 unelected justices in cases that most Americans never hear about until the ruling lands and the damage is already done. The Hemani case is not just about one man and one marijuana habit. It is about whether this country is going to have the courage to confront the systematic, selective, class-stratified reality of how constitutional rights are actually enforced in America, or whether it is going to keep pretending that the law applies equally to everyone while it manifestly does not. Millions of Americans have had their Second Amendment rights stripped, not through any fair, individualized process, but through broad categorical laws written by politicians who were more concerned with political optics than constitutional fidelity. Those Americans deserve better. They deserve a legal system that treats their rights as real, not as a privilege to be extended or revoked based on what is politically convenient in a given decade. They deserve a Supreme Court with the intellectual honesty to follow the logic of its own precedents wherever they lead, even when that means confronting the contradiction between what the Constitution says and what the government has been doing for 60 years. The ruling in United States v. Hemani is expected by summer of 2026. When it comes down, I will be here, breaking it apart line by line, telling you exactly what it means for your rights, your community, and your country. Because this is the kind of story that defines what America actually is. Not the America of speeches and bumper stickers, but the America that exists in courtrooms and police reports, and the lives of people who never made it onto the evening news. That America deserves someone willing to look at it honestly, loudly, and without flinching. If you are not subscribed to this channel yet, now is the moment, right now. Hit subscribe, turn on notifications, because we are going to be covering every development in this case, and dozens of others just like it, between now and that ruling. Leave your comment below. Do you believe marijuana users should permanently lose their gun rights under federal law? Do you think the system applies equally to the rich and the poor? Let me hear you. This conversation matters. Your voice matters. And the moment we stop paying attention to what they're doing in those courtrooms is the moment they finish building the cage. The rights you don't defend are the rights you lose. Don't let that happen on your watch.